Hi, it's Mike DelSignore. In today's video, I'm going to talk about the court process when you're charged with domestic assault and battery in Massachusetts. I'm a criminal defense attorney. I've handled cases throughout Massachusetts for years. I cover courts all over Massachusetts, and I want to outline what you can expect, what's going to happen in court. Now, when you're charged with domestic assault and battery, for many people, the victim is not on board. That could be your wife, it could be your husband, potentially children, friends, or somebody you're dating. But generally speaking, in most of these cases, the person who is the so-called victim of the case doesn't actually want to see you prosecuted. And I'll talk about the situation where they do. But for now, let's say the case is, as most commonly is, it's a spouse. You had an argument. Maybe you were out to dinner. You had some drinks. Things got heated, and the police came. So the police have to arrest somebody if obviously if there's any report of any kind of pushing, shoving, anything, any kind of unlawful touching, there can be an arrest. And even if the person tries to say, you know what, it was no big deal, we just got heated, they're fine, you can leave. Sometimes people will call the police just to cool things down. Well, the police have to make an arrest, and the case is then going to go to court. The next day, or if it's over the weekend, it'll be on a Monday. The next day will be arraignment. You'll enter a not guilty plea, and the case will get another date. Unfortunately, the case won't end there. So even though you might think, well, this is just a misunderstanding, we're going to go to court, we'll get dismissed, we'll wrap it up. Me and my spouse are on good terms. That's not what's going to happen, unfortunately. So at the arraignment date, you'll get another date for what they call pretrial. Now, at the pretrial, they'll give all the evidence. Now, the only real key, there's two key pieces of evidence in a case where the alleged victim's not on board. That'll be a 911 call and any statements you made. So the report and any statements you made, and any independent witnesses. Most of these cases, there's no independent witnesses. It's in your home. If there's an independent witness, they can testify to what happened, even if, for example, your spouse doesn't want to see the case prosecuted. Let me give you an example of that. Let's say you're out at a bar, and you have an argument with your spouse, and then there's allegations that you pushed your wife. Well, even if your wife is not on board with the case, the government could, and I'm not saying they would do this, but if the injuries were significant, theoretically, they could say, well, we're just going to call the witness to the stand and the police officers, and we're going to show that there was an assault and battery here. It's a weaker case if the alleged victim doesn't testify, but it still could get to a verdict, get to a jury. So that's one way a case can be proven without the victim. One independent witness. Second way, and this is probably the more common way if you don't have a victim on board. Let's say your spouse calls 911 and says, hey, my husband is hitting me. I need the police here. Well, that statement can come into evidence as what they call an excited utterance, an exception in the hearsay rule, an exception even to the most sacred of our rights as when you're charged with a crime. And that's the right to confront witnesses against you. And this may seem contrary to the language of the Sixth Amendment, but the call can come into evidence because in the U.S. Supreme Court's decided this, interpreting the Sixth Amendment. They say that the confrontation clause of the Sixth Amendment says that evidence can't come in if it's testimonial, that's how it's been interpreted. It's testimonial evidence. There's a case called Crawford versus Washington, decided in 2004 by our U.S. Supreme Court, and they said that if something is testimonial, the person's got to be on the stand. If it's non-testimonial, then it can come into evidence. And in defining non-testimonial, there's been similar cases to this where you have a 911 call, a report of a domestic disturbance. The court has said that a call for 911 isn't like giving testimony against somebody. It's basically a cry for help. It's trying to get the police there to help, and it's not to give testimony. So the statement comes into evidence even if the person doesn't testify. Now, this may change. The law could change. These are very closely divided decisions, 5-4 by the U.S. Supreme Court, defining the confrontation clause. And while generally speaking, the new justices, and we've had in the past, say, 3 years, ex-President Trump has appointed four actually, very conservative judges, and has basically changed the composition of the court. Now, in almost every area of law, this is negative, and it's going to hurt criminal defendants, and so certainly socially, there's certainly some negative decisions in that respect. But the one area where it may benefit individuals charged is the Sixth Amendment. So the law could get more pro-defense because those judges tend to read the Constitution very literally and say, testimony against somebody, you have a right to have the person testify in court. It's not something that should be interpreted. So we'll see how the law evolves there. But keep that in mind. If there's a 911 call, it's a possibility the case can be proven without the alleged victim testifying. Now, DAs don't always go this route. It's certainly a weaker case if the victim's not there. But if you have a bad record, if it's a significant incident, they may take this path and they may be more aggressive in prosecuting the case. Finally, if you admitted to the crime, then potentially they could prove the case as well without the alleged victim. So now that I've discussed how they can prove the case if the person who's the so-called victim isn't on board, let me talk about what's going to happen at the pretrial. The pretrial date is where the DA has to give us all the evidence in the case. The case doesn't get dismissed there. Finally, it will then be put on for trial. Typically, we put these, a lot of times you put them down for bench trial. So that on that date, if the victim doesn't want to go forward, if the government has no other options to prosecute the case, no 911, no independent witness, no confession on your part, the case should get dismissed. Most of these cases will eventually get dismissed. Usually they don't have that evidence. They could. So keep that in mind. If you have questions about the court process on a domestic assault and battery, feel free to reach out, 781-686-5924. You can call, text, anytime. I'll be happy to go over what is likely to happen in court, what are the steps from start to finish, getting the case dismissed, and what you can expect in court.